Jeffries.
Thank you, Mr. Chairman, and let me thank the witnesses for your presence here today and your continued contributions to the efforts of this panel. Attorney Benjamin, you mentioned something that was very troubling, and Dr. Baker, you agreed with it, the notion that federal criminal defense has simply become negotiation efforts toward resolution.
Right.
And that just seems fundamentally inconsistent with the notions that have always served to undergird our criminal justice system, the presumption of innocence. If there's going to be a presumption of innocence, it seems to me it cannot be the case that once someone is being investigated and/or is indicted by our government, that the only real option available to someone who, in theory, should be presumed innocent is to negotiate the most favorable resolution, which ultimately will likely result in some form of sanction and/or jail time.
Right.
So the question becomes, how do we unpack this dynamic in a way that allows this task force, the House, this Congress to make a meaningful impact? And I would suggest, and I would like to get the observations of both of you, that it seems to me that there's got to be some way to rein in the inappropriate exercise of prosecutorial decision-making. You referenced the term arrogance that exists perhaps amongst some prosecutors, and I believe the majority are operating in good faith, though I may not agree with the decisions that they make. But who, as it currently exists right now, has the capacity to oversee prosecutorial behavior and/or decision-making, and what consequences are there when inappropriate public policy decisions are being made? Start with Attorney Benjamin, and we'll go to Dr. Baker.
Well, the power of oversight and the power to rein in federal prosecutors resides in either DOJ and the Attorney General or the U.S. Attorney for a given district. The reality, however, is that rarely will these individuals want to interfere with the career prosecutors who have been doing this all their lives and are on the line. And so the answer is to take a look at the tools that are being used to produce this result. And I think that the biggest problem is the existence and the expansion of the use of mandatory minimum sentences. That is what gives the unfathomable power to federal prosecutors, because they can, in their charging decisions, threaten 10, 20, 30 lifetime mandatory sentences. That takes the judge completely out of it. If somebody is convicted, what we will say to our clients is, yes, sure, I understand you're innocent, and maybe you have a triable case, but if you lose, you will get a life sentence.
Right. Now, Dr. Baker, I appreciate that observation. Dr. Baker, I want you to respond, but also I want to add this observation. Currently, federal prosecutors have absolute immunity, as I understand it.
As long as they're,
in the context of their
prosecution, as long as they're not getting out of prosecution.
Right.
Sometimes they get involved in the investigation.
Okay. In the context of the prosecution, they've got absolute immunity. Law enforcement's got qualified immunity, as I understand it. Is that something that we should explore?
I guess as a former prosecutor, I liked absolute immunity when I had it. I haven't given it enough thought. I think that there is a reason for immunity, whether it should be qualified and more like law enforcement. The assumption is that a prosecutor is under the control to some extent of a judge in a way that law enforcement is not.
Right, that's the assumption, but I think the testimony that we've received is that that's no longer the case, that even Article III federal judges to some degree have lost control. So I'm trying to figure out—
But the real responsibility is with the President and then the Attorney General.
Right.
The political reality is that, I don't care what party you're talking about, that it depends on the particular U.S. Attorney and how he or she got appointed and whether they've got a senator protecting them. That's really what it comes down to.
One last observation. The problem that we confront is both to rectify the damage that's been done, but but also figure out how moving forward we can prevent a return to just a cycle of endless criminal statutes being added to the books. And it's often the case that elected officials react to the passions of the public. In fact, that's the kind of constitutional charge of the House of Representatives.
Right.
But in the criminal context, when you respond to the passions of the public, particularly as it relates to a particularly heinous crime, that results in perhaps doing things that in retrospect aren't in our best interest. And I would just encourage all of us, certainly those who are contributing to this effort, to think about that dynamic as we move forward.
Thank you very much. The time of the gentleman